Well, late this week, the social media company Meta shocked the Australian media industry by saying it will withdraw from negotiations that currently pay local media companies hundreds of millions of dollars a year in fees. Now, those payments originally came as part of the government's push to force social media companies to pay for news content that they access and then commercialise. Those most affected are Google and Meta, the owner of Facebook. But Meta on Friday said it will do away with a news tab on its site, as it has in the UK, France and Germany. It says news organisations will still be free to have their own pages on its sites, but Meta will not pay. The government, though, has powers under the News Media Bargaining Code. So what happens next? Professor Andrew Christie is the Chair of Intellectual Property at the Melbourne Law School and is also listed as a mediator for the Bargaining Code, and he joins me now. Professor, many thanks for your time. Just explain what is the next steps that either government, Meta or the news organisations can do?
Well, of course, one option is for nobody to do anything, in which case we're left with whatever the result Meta's saying it's going to achieve. It's presumably not going to scrape, or if it's going to scrape, it's not going to continue to pay for that. Another option, however, and one that seems more likely to occur, is the government has to decide whether it's going to exercise the powers that it gave itself a few years ago for exactly this situation. Now, those powers are essentially to declare that Meta now is regulated by the News Media Bargaining Code. And if that happens, then there's three additional stages that the parties could go through. The first stage would be for the news organisations to decide whether or not they wanted to enter negotiations with Meta. If they do, then Meta is obliged to negotiate with the news organisations in good faith for payment of for use of the news material that Meta is taking advantage of. If those negotiations don't succeed, i.e. if the parties can't agree what payment should be made, then the code mandates a second stage, which is that the parties can be sent to mediation, and both parties must mediate with each other in good faith. And mediation is a facilitated negotiation with the aim of getting agreement for how much Meta needs to pay. And if that mediation fails, the third and final step, and perhaps in a sense the most interesting step, is that the parties can then be forced into an arbitration, which is where a decision maker says, a bit like a parent to their children, well, if you can't sort it out yourself, I'll sort it out for you. And what I'll sort out for you is how much you have to pay. And the way I'm going to do that is each of you make a first and final proposal for payment. And I'll choose between those two. I'll choose the one that seems most reasonable.
Am I right to say, though, Andrew, I'll jump in there, am I right to say that the News Media Bargaining Code and these consequences you talk about, these were seen to be groundbreaking around the world and were seen to almost be a model for other countries to do similar things?
It's a model that other countries could choose if they wish to. Other countries have chosen a different approach. Europe, for example, treats this as an issue to do with copyright law and talks about, well, you're using copyright material and you have to pay a licence for certain uses. Interestingly, Australia never saw this as a copyright issue. It simply saw this as an imbalance of power issue. That's why the ACCC got involved, and the ACCC came up with this approach, which is often called baseball arbitration. Now, I think that must be because in the US, the baseball league must have some arbitral system whereby each party has to make a first and final offer and somebody will choose between the two. So other countries could have chosen this approach but haven't. And the Australian approach, therefore, as you identify, is right. I think it is unique.
So the one other aspect of this is it's the Treasurer who makes that decision to designate this situation where it either goes to negotiation or to mediation, those next steps.
Yes, that's right. Well, the Treasurer gets to decide whether it's going to insert Meta into this scheme. At the moment, Meta isn't inserted into the scheme. The news organisations have inserted themselves in, but there's no one to have the fight with until the opposition gets inserted into the scheme. That's the decision that the government through the Treasurer can make. It can say to Meta, I've now inserted you into this scheme, and these stages are going to unfold as I've just described.
And what is the prospect, as it's done before, of Meta simply saying, well, we may withdraw from Australia, we'll take Facebook out of Australia altogether?
It could say that. I doubt that it would take Facebook out of Australia altogether. More likely what it would say is, well, come and do something to me then. I might still scrape your news service, your news content and provide it. And then it's up to you to decide, am I breaking the law? Because, of course, this bargaining code isn't about breaches of the law. It's not about whether copyright law is being broken. It's simply about imbalance of bargaining power. If Meta didn't want to be involved in this scheme at all, it should reach agreement with the parties or face litigation. But this scheme is a better one than facing litigation because you get an outcome more quickly, and at least Meta would have a say in what that is by having negotiations, mediations, and if necessary, an offer in arbitration.
Professor Andrew Christie, great to get your input today. Many thanks for your time.
You're welcome.